I haven't explained a lot about Marbury versus Madison, and it's on the learning objectives. So here is a quick lecture on what happened in Marbury versus Madison, why it's such an important case. Okay, here's some background of the story. In 1800, John Adams lost his presidency to Thomas Jefferson. John Adams was a Federalist Party member. Thomas Jefferson was a Jeffersonian Party member, as the name suggests, right? The Jeffersonian Party was also called the Jeffersonian Republican Party. It had nothing to do with the current Republican Party, by the way. Actually, it's the same party as today's Democratic Party. It was at some point also called Democratic Republican Party, and then under Andrew Jackson, it became the Democratic Party. Okay, so two different parties, really polarized partisan rivalry. They hated each other. The Federalists under John Adams passed laws that restricted freedom of speech rights of Jeffersonians, for example. So there was a big fight over that. So in 1800, Thomas Jefferson wins the election, and the Jeffersonian Party wins majorities in Congress. Now, back during that time, there was a fairly long period, 4 months basically, of so-called lame duck Congress and lame duck presidency. That meant that the party that had lost the election was still in power for 4 months until the next Congress would meet, until the next president was inaugurated. Okay? So during those 4 months, what happened briefly was that John Marshall was nominated and confirmed as Chief Justice of the U.S., and John Marshall was the Secretary of State under John Adams, so he was a Federalist. Also, what happened was that William Marbury was nominated and confirmed as Justice of the Peace. And you see that his confirmation was just the day before the inauguration. So at night of that day, John Adams and his whole administration, including John Marshall, who had become Supreme Court Chief Justice, um, basically left. Adams actually left town. Now, what this meant was Marbury had been appointed and confirmed the day before the inauguration, but there wasn't enough time to deliver his commission, basically his job contract that he needed to start working as Justice of the Peace. I have some more information in a moment about what this means, Justice of the Peace, and this position involved. But the important point for us to understand is that as Secretary of State, it was Marshall's job to deliver this commission to William Marbury, but he ran out of time at the night of March 3, understandably, so he signed the commission, sealed it, and left it essentially on his desk for the next Secretary of State to deliver. The next Secretary of State, by the way, was James Madison, who was not a member of the Federalist Party, as many people are confused about this. He was a member of the Jeffersonian Party. Okay, let me quickly go over what else the Federalists did between losing the election in November 1800 and actually getting out of office at the beginning of March. So, in 1801, on February 13, they passed a Judiciary Act that changed the, the shape of the federal courts. Congress can do this. If you take a look at Article 3 of the Constitution, Article 3 creates the Supreme Court, doesn't even say how many justices there are on the Supreme Court. All Article 3 says is there is a Chief Justice, there is a Supreme Court, and Congress can create justiceships for the Supreme Court, and Congress can create lower courts. And in 1789, Congress had passed a Judiciary Act to create the federal district courts, for example, and so-called circuit courts, which are completely different from today's appeals courts, so we don't have to know too much about those. But in 1789, in this Judiciary Act, basically Congress created the first form of the federal court system, and we'll encounter this Judiciary Act in a few minutes again. So in 1801, Congress passed another Judiciary Act and changed the court system. So one thing that the old system did was it forced Supreme Court justices to serve as regional judges as well. So they basically had to get on horseback or into post coaches and stuff and ride to the part of the country where they were involved in regular cases as judges. This act got rid of this, and it created new courts instead of the old circuit courts, which involved the circuit riding stuff. And important for us, the Judiciary Act created new judgeships, like Marbury's Justice of the Peace Judgeship. Also, and this was kind of mean, that was really a dick move by the Federalists back then. They reduced the size of the Supreme Court so that Thomas Jefferson, the next president, they knew already who would be president, of the Jeffersonian Party, couldn't appoint any new judges anytime soon, right? Any new justices, sorry. So that was basically a completely political move to keep Jefferson from doing what the president has the power to do if there is a vacancy on the Supreme Court, right? So technically, legally, they could do this, but it was really mean to do that. So it really annoyed the Jeffersonian Party, obviously. Remember, high level of partisanship back in those days. Even worse than what we have today. Okay, so this is what happened before Jefferson became president. Now, what happened when, on March 4, Jefferson got into office? The new Secretary of State refuses to deliver the remaining commissions that are sitting on his desk. Basically, the new Secretary of State, which was James Madison, right, you may have heard that name before, said, you guys really screwed us here. He didn't use those words yet, more flowery language, right? But this is basically what he meant. You use this lame duck session to create all these judgeships, appoint all of those Federalists to those judgeships, and now we have to deal with all of those judges from the other party. I can do what I can do. I do what I can do to make this more difficult for you. For example, by not delivering those commissions so they cannot start working. And John Marbury was one of those judges that didn't get his commission. In addition, what happened next was that Congress repealed this new Judiciary Act that I just described. Basically introduced circuit riding again because now those Federalist justices had to travel around the country all the time again, which is really a hardship, and the Jeffersonians were saying, yeah, let's give them some hardship, right? Also, the new courts, the new structure of the court system was just abolished by this repeal of the 1801 Judiciary Act. Now, here's the problem with this. If you take a close look at Article 3 of the Constitution, it says that federal judges are appointed for life. So, what Congress had done in the 1801 law was create new courts and appointed new federal judges. And by overturning this 1801 law, what the Jeffersonians basically did was they kicked those judges out of office. That was arguably very unconstitutional. And the Jeffersonians feared that the Supreme Court would overturn that. So what did they do? They cancelled the 1802 term, basically told the Supreme Court, hey, you cannot make any decisions for at least a year. Okay, so you see political acting back and forth here, basically reducing the size of the Supreme Court in 1801 so that Jefferson cannot appoint anybody, and creating new judgeships that were stuffed with Federalists. And then in 1802, the Jeffersonians come in, or in 1801 they come in. The first thing they do is they overturn this act again by a new law, and then cancel the Supreme Court term, so that the Supreme Court cannot do anything against this. So the interesting thing here that happened was that Marbury, he was the Justice of the Peace, who did not get his commission even though he had been appointed and confirmed. And by the way, this Justice of the Peace position was not abolished by this new law that the Jeffersonians had passed. So this was still a valid judgeship in the District of Columbia. So Marbury sues Madison and says, hey Madison, you have the duty of delivering this commission to me, and I'm asking the Supreme Court to force you to do that. And the technical legal means to do this is a so-called writ of mandamus. A writ of mandamus is basically a legal order that the court issues forcing a public official to do what the public official is supposed to do. So Marbury went to the Supreme Court and asked for a writ of mandamus. Now this is where the 1787, sorry I said 1789 Act, I think it's 1789, maybe I have a typo here. Anyway, that's not that important for us here. This act basically had said the Supreme Court's original jurisdiction includes a writ of mandamus. Now here's the story. If you go back to Article 3, I really recommend that you read it. It describes the jurisdiction of the federal courts and the jurisdiction of the Supreme Court. And it lists things, types of cases that the Supreme Court can deal with basically as a trial court. So cases involving ambassadors, for example, or cases where one state government sues another state government. Every year there are 2 or 3 of those. Those cases are cases that the Supreme Court deals with as a trial court, really unusual. That's written in Article 3. Now, the 1787 Judiciary Act basically expanded this list of cases and said, for example, writ of mandamuses directed at federal officials are part of the original jurisdiction where the Supreme Court acts as a trial court. Okay, so that's why Marbury went directly to the Supreme Court to sue Madison, which is a detail that becomes important. Okay, so here is the tricky situation that John Marshall has to deal with. He has a problem, okay? On the one hand, he knows that Marbury should get his commission because he was nominated to be the Justice of the Peace in D.C. This position exists. The president, John Adams, had followed proper procedures. The Senate had confirmed Marbury. Plus, Marbury was a Federalist. John Marshall was a Federalist. Marshall said, I want Marbury to get his commission. Right? So as a Chief Justice, he could easily have issued this writ of mandamus forcing James Madison to deliver this commission. On the other hand, Marshall knew that if he ruled in Marbury's favor, Thomas Jefferson and James Madison would ignore the ruling. They would say, you know what, Supreme Court, we are not going to deliver the commission. And the Supreme Court was a new institution, and it had not established its authority that we know nowadays. So John Marshall knew that if that would happen, then the Supreme Court would lose all power, essentially. It would become pretty unimportant. So I know rage comics are out of fashion now, but still here's a rage comic that summarizes what happened. Next, John Marshall wrote the opinion for the court, basically ruling against Marbury. But look how he did this. In the opinion for the court, John Marshall said, does Marbury have a right to the commission? Yes, he does, because he has been appointed, confirmed, all of this. He should get his commission. Should the courts, provide Marbury with a remedy? Yes, they should. Now here comes the important question. Is the writ of mandamus from the Supreme Court of the U.S., the SCOTUS, the correct remedy? Marshall says no. And why not? Because the 1787 Judiciary Act is unconstitutional. Sorry, it's really 1789 now that I think about it, because 1787 was when the Constitution was written. Okay, so it's 1789. It's not important, but hey, we got it right now. I had a typo in the slides. So, why is the 1789 law unconstitutional? Because the Constitution, according to Marshall, declared what the Supreme Court's original jurisdiction was, and Congress cannot simply add to this. This argument is highly debatable. Many argue that it doesn't hold water, but this is what John Marshall argued. Now, here comes the important thing then of this decision. John Marshall then explained in detail why the Supreme Court can declare federal law unconstitutional. Okay? So here's what happened. Jefferson, in a sense, won. He didn't, or James Madison won, because he didn't have to deliver the commission to Marbury. At the same time, John Marshall won too, because he was the Chief Justice of the US, and he remained so until the 1830s. And he basically clearly declared that he and the Supreme Court now had the power to overturn federal statutes if they were unconstitutional. And who would decide whether they're unconstitutional? Guess what? The Supreme Court. Jefferson, his party was furious. They really raged against the Supreme Court, but they couldn't do anything because they got what they wanted, right? So, okay, so why is this important? First of all, legally, this is really important because Marbury versus Madison is now cited whenever the Supreme Court deals with the constitutionality of statutes. The Supreme Court then says, look, we can declare statutes unconstitutional. Look at Marbury versus Madison. So legally it has been really important. It's also important because it shows us that often Supreme Court outcomes are the result of politics, strategic behavior, in a conflict between Congress, the Supreme Court, and the President, where the Supreme Court sometimes can get something out of this conflict by making a decision that it doesn't really prefer that much, but if it does it in the right way, it can get some political gain, and the other institutions can lose. Right? So we have a combination of legal interpretation, but also smart political behavior. Now, one reason the Supreme Court got away in that case, obviously, was because Jefferson couldn't do anything. Madison couldn't do anything. They didn't want Marbury to get the commission, and that's exactly what the Supreme Court gave them. So they couldn't really, they could be angry. They couldn't do anything else. Another reason the Supreme Court got away with this was that there was another decision coming out that year, in 1803, and that's what people focused much more on. And that was the Supreme Court decision that decided whether the 1802 Repeal Act that repealed the 1801 Judiciary Act was constitutional. Remember, I explained that basically this 1802 Repeal Act that overturned the 1801 law kicked federal judges out of office, and those federal judges under Article 3 of the Constitution were supposed to be appointed for life. You cannot easily kick them out of office. You would have to impeach them. Congress just passed a statute to get rid of them. And the Supreme Court declared that Congress could do this. If Congress got rid of the courts, the judges lost their office as well. And that diffused some of the conflict as well, because the Jeffersonians got something they had wanted, right? So the Supreme Court gained some, made some concessions to the Jeffersonians, and in the long term it really won the power or the authority to overturn statutes by declaring them unconstitutional. Alright, if you have any questions, please leave them in the comment section of this discussion board.